This page we've been given is from the old guidance.
It is, my lord. If I can just introduce it and pause my submissions to introduce that. My lord raised a question in respect of page 202 of the supplementary bundle and the current guidance, where it deals with vehicle crossovers. And the issue was, where does the application of the 25mm upstand apply in vehicle crossovers? This was a figure that was included in the original 1998 guidance, but it was actually omitted from the updated guidance.
I see. And it's the lower of the two parts of figure 14, which illustrates where the upstand goes.
Absolutely.
Yeah. All right. Thank you very much.
Well, I was, prior to lunch, just going through to demonstrate to the court how the Secretary and those advising him had considered the issue of kerb heights.
Yes, we got to page 548.
And we had got to page 548. Great. And this was a consultation report produced by TRL, but it referred to a meeting of the steering group. That is at section 2.1 and the third paragraph under there. A meeting of the steering group held on the 4th of May 2021. That's after the workshops had taken place. And the steering group included on it a number of representatives of DFT, but also from the Disabled Person Transport Advisory Committee.
Yeah.
And you'll see from the second sentence that during that meeting a consensus was reached on which feedback should be taken on board on this iteration of the guidance documents and what should be passed to the client for future consideration of the guidance. And then what happens is that the consultation report from page 563 onwards summarises in tabular form the feedback that was provided both written and orally at the workshops, and does so thematically. And within that we need to go to page 576 of the supplementary bundle, where kerb heights are addressed for the first time. And the issue of kerb heights runs over a number of pages to page 584. The column one needs to look at is the final two columns, specific change to be made to IM GU TPS. And the conclusion was that no change is required, refer to client to consider messaging around this, and then potential future updates, DFT to consider for future iterations. And so the conclusion reached following the workshops and by the steering group was that the issue of kerb heights was a matter that should be considered for future iterations. Now, of course, this is May 2021, shortly after having received the inclusive design report published in February 2021. It's not surprising, in my submission, that the conclusion was thus. Now, it's fair to say, in transparency, if one runs through the number of representations in relation to kerb heights, the vast majority of them took issue with the 25mm stipulation. Some of them suggested that should be replaced with a 60mm stipulation, but it's clear that that was an issue that was raised and was grappled with. Just to note that it didn't all go one way. If we turn to page 583, you'll see that there were representations from Sustrans, which are a sustainable transport charity, and they noted that the kerb height would be a problem for wheelchair users, and we're still not considering a study.
Was this in the context of the consultation exercise, which was found to be unlawful?
It was.
Well, does that potentially have some significance on the... I know that the consultation ground is no longer a live issue before this court, but one of the points, as I understand it, the judge made was that there might have been some other consequence if there had been proper consultation. For example, it might have been concluded that there ought to be some kind of caveat.
The judge did say that, and obviously we sought to appeal and weren't granted permission, and the appellant also sought to appeal the declaration, weren't granted permission in relation to that.
Right, well, but we are where we are, with the judge's conclusion that the consultation is unlawful in place. but also with the consequence that there was no quashing.
Absolutely. As I understood it, the concession that was that it would have made from my learned friend, that a finding on the consultation ground 3 alone was not sufficient to justify the quashing on all or part of the guidance, and the judge accepted that. And then there was a dispute about the form of the wording.
Yeah.
The reason I was taking the court to this is to show, notwithstanding the basis on which the court found that was unlawful, it was because there was the period of time that was given predominantly, that the issue of curb heights was grappled with and was raised and considered by the steering group. It wasn't something that was ignored. That obviously comes with the caveat that the lower court has found that the consultation process was unlawful in itself. Thank you. So that's May 2021, and then turning back to my skeleton argument for the chronology at page 9 of my skeleton, there then was a meeting with the RNIB in October 2021 where this matter was discussed again. The meeting notes from that found at page 134 of the supplementary bundle.
Sorry, which page?
134.
Thank you very much.
And as I say, this was a meeting between officials at the DFT and representatives of the RNIB, and it says discuss updates to the inclusive mobility and tactile paving guidance documents and guidance on share space, and it's the former that we're concerned with. And we can see from 2 there was a note of discussion, and at C, the RNIB reminded the DFT of the curb height concerns. The DFT explained projects with TS's Transport Scotland looking into this bus stop borders and continuous footpaths 2023, after which it will reflect upon the findings and implications for existing guidance. DFT explained that the curb height research is looking at heights, projected characteristics, curb types, weather conditions, and is due to be published late 2022, early 2023. The department didn't want to change the guidance now and then have to change it again once the further research is published. Pausing there, the officials, at least, DFT, were recognising that there was a value in adopting a consistent approach, not changing existing guidance without a good reason to do so, and particularly didn't want to chop and change that guidance. We then go on at D, where reference is made to the UCL report again, and at the bottom of last sentence of D, the DFT confirmed there's no intention to discredit UCL research, but to ensure a robust evidential basis for changes to government intervention such as guidance. And in my submission, it was open to the Secretary of State and to those advising him to take this view, particularly in light of the inclusive design conclusions, and to take the view that they should only amend existing guidance where there's a robust basis to do so. That was plainly their position. We then need to turn to correspondence between the RNIB and the Minister for State. We need to turn to page 637 of the bundle. I think it's the very last page in the supplementary bundle. For your note, this is responding to a letter which is in the bundle at page 213, for your note, where the Chief Executive of the RNIB specifically requested that the reference to 25mm be replaced with a reference to 60mm. And this was the response of the Minister for State.
Sorry, what was the reference to the original letter?
213.
Thank you.
There's a discrepancy in relation to dates, my lord, you may have picked up. This letter of the 9th of December says it's responding to a letter of the 30th of November. It actually is dated the 24th, but if you look at the substance, it's plain that it is responding to that letter. And at page 638, top of the page, in effect, the court can read it, but in effect, the Minister of State was reiterating that which the officials had told representatives of the RNIB a month prior. And then finally, we turn to the ministerial submission, which is at page 633 of the supplementary bundle. There's actually a ministerial submission made slightly earlier than the letter we just looked at on the 25th of November. I'd ask the court, obviously, to read this in detail in due course, but to note paragraph 7, at page 634, that the final drafts of the guidance were before the Secretary of State, had been reviewed by the steering group and by officials, and then at 8, they indicate that they expect stakeholders to broadly welcome the updated documents, especially given that they're around 20 years old. However, there's potential for some negative reactions. We believe these are manageable with publication that's done with messages that, and then there's a number of indications of what should be said publicly and then what was said publicly on the website. The guidance will not be left untouched for another 20 years. That's the first point. The second point, that the updates are outcomes supported by recent research, which provided a better understanding of many items, but not all potential additions. That C, that they consider it was right to publish the updates, but also to invite suggestions and evolving evidence which might inform future updates through ongoing ITS work, and that the next update might, depending on new evidence, be considered within a 5-year period. And then particularly at 9C, says it made reference to the fact that some disabled persons organisations, including the RNIB and Disability Rights UK, have preferences for some further technical changes, the evidence for which remains equivocal. And that plainly was a reference to the issue of kerbites, or at least included a reference to the issue of kerbites, and the position of those advising the minister was that the evidence was equivocal. And the Secretary plainly followed the advice of his officials and published the guidance in the form that was attached to the ministerial submission. We then turn to Ms. Frank's first witness statement, first of all, page 30 of the supplementary bundle. And paragraph 16 she sets out there the explanation that was set out on the landing pages for the guidance, and included her second quote that the DfT expected to review this document frequently in future, responding to evolving research, people's needs and best practice. We will consider feedback, evolving evidence and research to inform future updates. The next update will be considered within 5 years. So it's the public statement to that effect, and although it doesn't mention specifically the Transport Scotland research, that plainly was research which informed that statement. And then if we turn over to page 35 of the bundle and paragraph 34, this is a section where Ms. Franks had summarised the consideration of the UCL study as part of the updating process, and to ask court to read paragraph 34 of witness statement.
Yes.
And that is, it must be a pithy encapsulation of the position of the Secretary of State and his officials. The final series of documents, just in relation to what's happening with the ongoing research. The position as it was before the judge was set out in Ms. Frank's witness statement of paragraphs 48 to 51. And that's, so I should have asked the court to look at that while we were there. Starts page 39 of the bundle. Page 39 of the supplementary bundle.
Yes.
And the point which draw to the court's attention is paragraph 51, where Ms. Franks explains what will be done, intended to be done, once that research is available. Now, as I've made clear, when the decision to publish back in January 2022 was made, it was expected that that would be available later that year or early the year after, early 2023. By the time the evidence came for the evidence in the High Court, that had been pushed back to spring of 2023. And we know from Ms. Frank's updating with evidence to this court, we're now probably looking at March 2024 for the final phase of the research. Just on that, what has happened since the matter was heard by the High Court is that the first phase has completed, and also it had completed, sorry, before the High Court, but the research had not been published, so therefore was not available. It became available in April of this year. That is the exhibit to Ms. Frank's second witness statement. I can just briefly make a couple of points in relation to that. You'll see it's not within the bundle. I hope.
I don't think I've got a copy of it.
I did foresee that might be an issue. I do have one spare copy. I don't know whether.
Do you have it?
No, I don't. Was it sent electronically? I may have it.
We made an application well before the bundle was put together. To allow us to reduce the evidence of Ms. Franks, and also, does the court actually have the second witness statement of Ms. Franks, though?
Which one?
The second witness statement of Ms. Franks.
I think I've only got one.
Okay. Well, I think Ms. Burton, given that you didn't object and that the court were going to order that it's admissible, is there any objection if I hand up? I only got one hard copy. That's the only issue.
Well, we'll make do with it for the time being, but could you provide us with some more?
Absolutely.
I mean, obviously, if it would assist, I'm sure a copy could be emailed to any relevant email address, instantaneously. If that would be preferable to having a single shared hard copy.
Certainly, I would be able to access it. That would be helpful.
I'm very sorry about this, my lord. I thought when it was introduced by Mr. Burton that we were aware of it. We'd made an application some time ago. I can't recall exactly when it was.
I'm afraid it passed me by.
No, well, I'm very sorry about that. There was a debate amongst the bench as to whether it should be put in the bundle, but because the application hadn't been determined, and because of the tight limits on page numbers, it was suggested that wouldn't be appropriate.
Right, so she says that. Oh, isn't it? I think what you've given me is more than one copy, actually.
Oh, sorry. I'm absolutely right. I did print out 3 copies of the witness statement, only 1 copy of the exhibit.
Yes, I think we have got 3 copies. We've got 3 copies of the exhibit. I don't know.
No, we don't. Sorry, that.
There we go. There's the witness statement.
Thank you.
I think we only have one copy of the exhibit, yes. But anyway, that is the phase 1 report, which
That's the
perhaps
phase
we don't
one
need to look
report.
at in any great detail.
Pardon, my lord? Sorry. I'm sorry.
Perhaps we don't need to look at the
No.
phase 1 report in any great detail.
No, I'm going to give you a couple of references for the
Yes.
report, but no, not in great detail. One caveat, although it is dated on its face November 2021, as Ms. Franks explains in her paragraph 5, it was actually published in April of this year,
Yes.
which is why it's available to the court below.
Yes.
In short, and I fully accept that this document, the appendix, was not before the Secretary of State at the time made the decision. So to that extent, it is, the court may consider it has relatively limited relevance. But it is of import in two respects. Firstly, it further underscores the limitations of the UCL study, as Ms. Franks explains at paragraphs 7 to 9 of her witness statement, and just for your note, can be found at pages 19 to 21 of the exhibit itself. And then secondly, for your note, my lord, you'll recall when we were dealing with the question of vehicle crossovers,
Yes.
I made the submission that there were other standards where that 25mm standard applied. That can be seen from table 3.1, which starts on page 22, just for your note, my lord. And if one looks at the standards applied by the DMRB, by Streetscape, by Northern Ireland, which we've seen, and by the London Cycling Design. And then also for your notes, if the court would also look at the conclusions at page 32.
What was the previous reference there? Page 21 on the
It's the
PDF or the...
It's the table that starts at page 21 of the exhibit. Table 3.1.
I'm sorry, I don't have a table on that page.
Of the exhibit AF5.
Yeah.
There's a
Table 3.1.
yes, that's right. It's page 23.
Yeah.
I thought you said 21. I'm
Sorry. And just so my old friend is with me for issues of reply, if one turns to page 25, you'll see the design manual for roads and bridges suggests a kerb interface between footway and vehicle carriageway, not at a crossing or crossover location. That's the standard kerb of 100mm and 75mm rural, but that at a pedestrian crossing point, the suggestion should be that it's flush or a maximum of 6mm. Obviously, that's consistent with the guidance under challenge. And then over the page, at page 26, the streetscape guidance. This does pick up the UCL research, the child's research for kerb interface between a footway and vehicle carriageway, not at a crossing or footway crossover location. So situations that are not dealt with by the guidance in question. But then it says kerb interface between footway and vehicle carriageway at pedestrian crossing points between 0mm and 6mm, so consistent with what is provided. And then also kerb interface between footway and vehicle carriageway for crossover, driveway or vehicular access, 25mm. And if one goes on in that bundle page 32, there's a summary of the standards applied. This is at 3.5.2, where there's a kerb interface between a footway and vehicle carriageway at a crossing point. And you'll see that, that in short, what is said is that the kerb height at a pedestrian crossing should be flush or no more than 10mm, and most of the standards apply the 6mm standard that is applied in the guidance and the challenge. And then over the page, page 34, para section 3.5.3, this is dealing with vehicular accesses. The literature review suggests kerb heights range from 10 to 40mm vehicle accesses, but you can see from that the 25mm upstand is stated in a number of guidance cases. The point being, I don't place much evidence on it, is that the guidance in question, as I've said, is dealing with specific circumstances, vehicle crossovers, pedestrian crossings, and it's not inconsistent with guidance elsewhere.
Mr. Williams, I've been trying in my mind just to visualise what we're actually talking about, what we should have in our mind with the vehicle crossover. So can I just ask you for your help with that?
Absolutely.
Okay, so obviously you've got the carriageway,
Yes.
where vehicles are usually travelling, and alongside that you've got the pavements, and at some point the pavement will meet the carriageway.
Yes.
And if I understood this correctly, the standards you're reminding us of usually provide for that to be either flush or close to flush.
Where there is a vehicle crossover. So if I pick up
that's what I'm talking about.
Absolutely.
So I just want to have, don't show me anything else.
sorry.
I don't mind. I just want to visualise it in my mind, all right? So if I have the pavements where they meet the carriageway, 25mm is nothing to the point at that meeting place. Is that right? We're talking about something between 0 and 6mm there.
At pedestrian crossing points.
Yeah, I thought we were talking about vehicle crossovers.
At vehicle crossovers, it's 25mm.
That's what I'm. Okay, that's what I'm not. At the point where the pavement meets the
Absolutely.
carriageway, it has to be 25mm.
That's why I introduced the figure 14.
I see.
So the car is going to drive over a 25mm curb
Absolutely.
in order to reach the carriageway, also in order to come off the carriageway.
In order to come off the carriageway to turn into the petrol forecourt or the residential access. Absolutely. That's what figure 14 shows.
Right.
My friend.
So where does the 6mm come in? Where's that irrelevant?
No, the 6mm, my lord, applies where there's a pedestrian crossing across the road.
Sorry, just stick to vehicle crossover.
Oh, it's not. It doesn't apply.
It's irrelevant. Okay, right, well, that's fine. That's very helpful.
Grateful, my lord. Does my lord follow where the 6mm tolerance comes from, and that's in relation to pedestrian crossing?
Yeah, I understand.
So if the pedestrian, just think of it as a cross, if you like, with one axis being the vehicle and the other being the pedestrian, the 6mm comes in when the pedestrian is crossing on one axis and the carriageway, the vehicle crossover is on the perpendicular axis.
My lord, no. They're talking about two separate interventions into the street design. One is, it might be helpful if I go back to the guidance and some figures. If we pick up the guidance,
Well, if I look at figure 14, for instance, page 205, and that's more or less in the shape of a T, and if I'm the pedestrian walking along the footway,
yes,
I cross over the blister paving, and then there is shown diagrammatically a curb, and that's the 6mm. If
it's either flush or up to 6mm.
Yes, where the black triangles are, that's the path the vehicle is going to take, and that's where the 25mm curb comes in. Is that right?
No, my lord, because that's not a vehicle crossover. That's
sorry.
That's so I think the easiest way to look at it is if one picks up figure 3A at page 187.
187.
This is an example of a pedestrian crossing point. Let's put vehicle crossovers out of our mind at the moment. This is simply, in this instance, a controlled crossing point. The curb is dropped, as we've discussed previously, and that has to be flush. In accordance with the guidance, has to be flush or up to a maximum tolerance of 6 millimetres.
Yes.
25 millimetres doesn't enter the picture
No.
at this stage.
No.
Right. Well, I think what we're really interested in is where does the 25 millimetres come in?
Well, as I said, it comes in with the vehicle crossovers,
Right.
And the text for that is at page 202.
But there's no diagram in this guide.
But there's no diagram in this guidance. To understand it, one needs to look at the. Maybe in the future iterations, this may be taken on board because we may have proven.
But that's why I was trying to have a picture in my mind, and the best we can do is the old guidance.
I think no. Does that assist? I hope so.
Right.
Right. I've finished going through the documents, and I can move now to the legal principles, which the court is going to be very familiar with. I set them out at page 13 of my skeleton argument, and I just need to make a few submissions in relation to them. I have a heading of supervisory jurisdiction. This court will be very familiar with its limits in that regard, and I need to say nothing more about it. And then over the page, the question of irrationality and unreasonableness I address, and I cite the Law Society case there. And in the Law Society case, the judgment of the court indicated that this court will be very familiar.
Is that a division? Was it Court of Appeal? You say Court of Appeal. I thought it was divisional.
My lord, I'm so sorry if it wasn't.
But forgive me if I'm wrong.
No,
I thought it was divisional.
You may well be right.
I think perhaps it's quoting from the divisional court, is it?
Perhaps.
You're absolutely right, my lord. It is a divisional court case. I'm so sorry.
The reason it may matter is I was going to ask you whether this passage has been considered by the Court of Appeal, either with approval or disapproval.
Yes, that's a mistake on my part in the skeleton argument as well. For some reason, I was under the impression it was the authority of the Court of Appeal, and I apologise about that. I'm not immediately.
No, I'm not aware. I'm not aware it's been commented on by this court previously.
No.
Which is one reason I asked the question.
If it would assist my lord, obviously, I can research that discrete point.
No, I don't think.
I don't. The analysis of the court was that irrationality can be considered in two respects. Firstly, concerning the substance of the decision, where you apply the traditional Wensbury formulation of so unreasonable, no reasonable authority could have ever come to it, or to avoid the tautology outside the range of reasonable decisions. But it also has a secondary aspect, which is the procedural aspect. The question being, is there a demonstrable flaw in the reasoning which led to the decision? And that's where you see that there are instances of decision makers taking account of irrelevant considerations where there's no evidence to support an important step in the reasoning, or that the reasoning involved a serious logical or methodological error. The court in that case, as you can see from my skeleton, said that the test of unreasonableness is a high one. I don't think there's any dispute between us on that, and in my submission that applies to either aspect of irrationality. But I just would wish to make some submissions on the second aspect of irrationality as analysed by divisional court, and what it does and does not mean. The second aspect is concerned with process, and the court was recognising that where a decision maker has relied on a finding or a proposition as part of the reasoning process, which is demonstrably flawed, then that may be a basis for challenging under the head of rationality. And we have examples of that second aspect of rationality in the bundle. So to give you one example, the Lunt case, which is at tab 2. Just if we can turn that up.
This is the one about the taxis.
This is a taxi one, absolutely.
Yeah.
It was a challenge to the refusal by the City Council to licence a taxi which was designed to accommodate all wheelchairs. And if we turn within that to page 43, that's right, I'm sorry, paragraph 43, page 83. You can see that the primary submission of the claimant there was that the decision was liable to be quashed because the judgment of the committee was based on a fundamental misunderstanding of the true factual position. In my judgment, that true factual position was a mandatory relevant consideration. Then at paragraph 44, Mr. Justice Laing concluded that a lawful exercise of discretion could not be performed unless the committee properly understood the problem, its degree and extent. Makes reference to the Wednesbury case, but that, he says, only applies to decision makers who have acted fairly and directed themselves accurately on the relevant considerations to be weighed in making a matter of judgment or exercise of discretion. And then at paragraph 45, he indicated that the committee had clearly based its decision on an erroneous belief, and then set out the three ways in which the committee had erred as a matter of fact. I use that purely as an example of the second aspect of irrationality. And I say that that second aspect shouldn't be treated as authority for a very different proposition, which concerns the substance of the decision. And that proposition being that in order for a decision to be rational, it is a prerequisite that a decision maker must be able to point to specific expert or empirical evidence to support it. And it's certainly not authority for the proposition that unless guidance or policy is supported by specific expert or empirical evidence, it will necessarily be irrational. And in my submission, guidance is often the product of evaluative judgment, sometimes where the evidence base is inadequate. My Lord, that's a point on irrationality, and I'll return to that in relation to ground 2. Turning to the duty of inquiries, which I deal with at paragraph page 14 of my skeleton. No dispute between us. The tame side is a specific application of the doctrine of irrationality, and the paragraph 38 I cite from the Campaign Against Arms Trade case, which was a case of the Court of Appeal, which I believe my Lord Singh was on the bench, and the court will therefore be very familiar with the principles to be applied in the Tameside cases, which I set out at page 15. What I would emphasise, just for your note, that the court in the Campaign Against Arms Trade case emphasised at paragraph 57 and then paragraph 152 that the threshold of rationality was a strict standard, a high threshold, and that proposition applied to the Tameside aspect of rationality as well. I don't believe there's any dispute at the bench amongst them.
But this goes back to characterising what the decision was. I mean, the Secretary of State accepts that he was in no position to provide a firm and definitive recommendation on curb heights until he had made further inquiries.
Absolutely.
So the Secretary of State's own position was that the Tameside duty of making inquiries had not yet been completed.
Absolutely.
So it may make a difference whether you say that the publication of the guidance was a decision to recommend the 25mm, or whether you say that the publication of the guidance was a decision not yet to change the old guidance.
And in my submission, it was the latter. As I said, I submitted previously, I'm not disputing the fact that a challenge could be brought, that there was a decision to maintain that guidance, but it was simply to maintain that guidance pending the outcome of the ongoing research. And as I have said to my Lord Justice Singh in answer to the question, it is the Secretary of State's position that in commissioning that research, he was acting in compliance with his duty of inquiry. And on the duty of inquiry, just at paragraph 39 of my skeleton argument, it was held in the Carl's Academy's case, which is a High Court case, I appreciate that, and I don't understand that it has been held to be the case at the Court of Appeal level. It's held that the duty of inquiry which arises under the public sector equality duty also applies a Wednesbury or rationality standard. As I say, I haven't. I'm not aware of authority at the Court of Appeal level which endorses that, but there's no dispute at the bench that is the appropriate approach to take, as I understand it.
The other thing that the court said in the Carlser case was that the burden of proof remains on a claimant, because I think there was some dispute in argument about whether what we had said in the campaign against the arms trade, or was it the Bridges case? Anyway, there was some concern that the Court of Appeal had muddied the waters and suggested there was a reverse burden of proof. But anyway, that's been clarified.
Yes, that's right. I mean, I like my learned friend, I don't claim to have founded my case on the burden of proof.
No.
But in my position, that's correct analysis of law.
But I mean, in a sense, the tame side duty doesn't really matter. It would matter if the Secretary of State said, right, we've done enough, we can make a decision.
Yes.
But that's not the Secretary of State's position.
Absolutely, and this is why the judge below was right in my or was open to him to deal with the two grounds compendiously, because actually, as I started my submissions, there's one question, or there was one question for the Secretary: was it irrational for the Secretary of State to maintain the existing guidance when it had on kerb heights, when it commissioned further research into the issue?
What Mr. Burton says is that to publish the guidance in 2022 in unqualified terms is irrational, and that at least it had to be flagged up that this was for the time being because there's a state of uncertainty in the evidence, we're doing further research, or some kind of caveat should have been issued, maybe an asterisk, as we've seen elsewhere. But I think his fundamental submission against you is that simply to repeat what had been said more than 20 years earlier, it is, in 2022, irrational.
He does. That's his straightforward ground to proposition, it appears to me. I will address the court on ground two when we get there, but the ultimate...
Sorry, don't take it out of order.
To answer your question, the ultimate position, the ultimate submission I would make to this court is this court might consider that it would have been preferable to have included a caveat to it there. But in my submission, that is not enough to found a ground of irrationality. It wasn't irrational in the circumstances, and I'll lay out the circumstances for the court when I get to the ground two, for the Secretary of State to proceed in the way he did. Well, that's the legal framework. The grounds of appeal there are twofold, and I address those. Ground one, at least, sorry, page 18 of my skeleton, starting at paragraph 44. And the way it was analysed, at least in the skeleton argument, was that there were two flaws in the judge's analysis when he found that there was no breach of the duty of inquiries. The first allegation made in paragraph 30, subsection 1 of the skeleton argument, is that once the judge had found that there was a clear consensus that further research was needed, and once that was accepted by the Secretary of State, the only logical conclusion was that there had been a breach of duty of inquiries. And I addressed that in paragraph 45 of my skeleton argument. In short, we submit that there was no logical flaw in the judge's reasoning. The Secretary of State had recognised that there was a consensus that further research on the topic of kerb rights was necessary, and he'd responded to that consensus. He had, back in spring 2021, jointly commissioned research into that topic, and as I've said on a number of occasions, that, in our case, was consistent with the duty of inquiry. That did not foreclose the question of what should happen in the period until that research was completed. And that question was for the Secretary of State, subject to the constraints of rationality. whether to publish the guidance at all, updates to the guidance at all, and if so, what to do about the existing guidance on kerb heights. Now, we know that the Secretary of State decided to publish 2022 updates, and he did so because he thought there were important updates on other areas that needed to be done, and he decided to retain the existing guidance on kerb heights. The question for this court, and the question for the court below, was whether that was open to the Secretary of State, whether that was irrational or not, and that was the approach taken by the judge. There's no error in his logic in my submission. The second basis of challenge is that the three factors relied upon by the judge were not open to, when he concluded that there was no breach of the duty of inquiries, were not open to him. And to respond to that, we need to go to the judgment of His Honour Judge Jarman, paragraph 53 of the document. And there he relies on three factors justifying his conclusion that the Secretary of State's decision to maintain the 25mm minimum in the meantime was rational. And I deal with this in paragraph 46 of my skeleton argument, but addressing you briefly on them.
Just before we go to the reasons, is the judgment a political judgment, as the judge said it was?
My learned friend said, well, that's not apposite. And I would accept it's not political in the normal sense of the term. It may have not been an apposite reference. The reason why I submit that the judge used the term political judgment is that if we turn back to paragraph 40, he refers there to the proposition that's been emphasised many times that judicial review is not an appeal against governmental decisions on their merits, the wisdom of government policy.
He's using political in the sense of as a matter of policy.
Absolutely.
Yeah.
That's the reason. And so it may, if we want to be hypercritical, be loose language, but that's the basis on which he used it. And to be fair to my own friend, I don't think he would have founded his case solely on that point. I don't understand him to do so.
Anyway, you're going to tell us
Factor
about
one.
the three factors.
Yes, so the first factor he relies on was the results of the research were expected in a year or so. And my own friend, at least in the skeleton, says, well, you can't cure what would have otherwise been an error of law by saying you commissioned research into it. But in my submission, that was a relevant consideration for the judge when considering whether the decision was irrational or not. It was relevant that research had already been considered and the results were expected in a year or so. And it can be tested in this way. It's plainly relevant to the rationality of the decision to hold the ring, as it were, to maintain the status quo, that the results were expected then in a year rather than 5 years or 10 years. It is a relevant factor, and certainly not an illogical factor for the judge to have taken into account. The second factor was that the guidance deals with a very wide range of topics, which kerb heights is a small, although important, issue. Again, in my submission, that is a plainly relevant factor. And again, it can be tested in this way. If this was guidance that was solely or even primarily concerned with kerb heights and minimum kerb heights, then different considerations may have been at play. But as we've seen, the references to kerb heights are limited to one type of tactile paving and specific interventions into the highway network. And it was open to the Secretary of State, in my submission, to conclude that other important updates to the guidance should not be put on hold until the research into kerb heights was obtained, to carry on and publish the 2022 guidance, as opposed to put it all on hold and await the outcome of the ongoing research.
In other words, what you're saying, I think, is that the decision to publish the guidance was a unitary decision which can't really be chopped up into little bits.
Absolutely. And certainly was a relevant factor that the judge was entitled to take into account when considering the overall rationality of the decision by the Secretary to publish the 2022 guidance. And then thirdly, he refers to the fact that the guidance makes clear that there should be relevant engagement in schemes for tactile paving. And again, I say that was a factor the judge was entitled to take into account. What we're concerned with here is guidance. We're not concerned with regulations. That the standards are not absolute. And it's clear from the passage I've taken this court to in the tactile paving that the technical aspects of the guidance are to be applied in accordance with the key principles in section 1, including the need for early and diverse engagement. And that is a factor that the judge was entitled to take into account when concluding on the rationality of the decision. It may be different, for instance, if the Secretary of State was considering publication of regulations or an order providing or prescribing minimum curb heights. So that's ground 1. Ground 2 is the rationality ground, and it might be really the heart of the case. My learned friend has put it on his sheet today. And the case is straightforward, that it was irrational for the Secretary of State to maintain the existing guidance on curb heights when there was no evidential basis for that. And I say it was not irrational. It was both within the range of reasonable decision makers, within the range of reasonable decisions open to him, and there was no demonstrable flaw in his reasoning. And I say that for the following reasons, and it really just encapsulates these 5 reasons, what the submissions I've already made, but just to encapsulate them. First of all, the context here is critical. The guidance does not establish minimum curb heights across the public realm. It's concerned with curb heights in a limited and specific circumstances. Secondly, whilst the Secretary of State is unable to identify any specific empirical or expert evidence on which the 25mm stipulation was based, it's wrong to characterise that evidence as arbitrary. We know that guidance was based on research, we know it was undertaken in consultation with persons with a wide range of impairments, and we know that specific consideration was given to the question of detectable curb heights. It's plain that an evaluative judgment was reached on that issue. Thirdly, the Secretary of State was of the view that the existing guidance should not be altered unless there was robust evidence to do so. That, I say, was a judgment open to him that cannot be characterised as irrational. That's particularly the case when the guidance had been enforced and informing designs on the use of tactile paving for over 20 years. Fourthly, the Secretary of State reached the judgment that the available evidence was not sufficiently robust to warrant a change from the existing guidance. As we've seen, he concluded that the evidence was equivocal. Again, in my submission, in light of the evidence I've taken the court to, which was grappled with by the Secretary and those advising him, that was a decision open to him. And fifthly, and finally, this is not a case where there is a flaw, let alone a demonstrable flaw, in the Secretary of State's reasoning. The Secretary of State didn't mistakenly assume that the original guidance was supported by empirical evidence or expert opinion. He was aware of the evidence in respect of curb heights, and he concluded it was equivocal. And therefore, his judgment to retain the existing guidance pending the outcome of research was informed and not based on a misunderstanding of the available evidence. And as I say, and I've said to my Lord, it would, of course, been open to the Secretary of State to take a different approach. He could have included a caveat. He could have included a range. It may be that this court thinks that it would have been preferable for him to do so in the cold light of day. But in my submission, that's not enough to justify a conclusion that the high test threshold is met. My Lords, my Lady, unless I could be of any further assistance, there's my submission.
It's just a passage in the judgment. Could I just ask you, Sir, if there's a passage in the judgment which I found a little bit difficult to understand. I was wondering if you could help me with it, please. Let me just see if I can find it. Yes, it's paragraph 22 of the judgment. If we go down sort of 4 lines down, there's I think there's some kind of a typing mistake here,
Yes.
and I was wondering if you had any idea.
I don't know how that occurred, because if that had been in the draft judgment, I am
You
pretty
thought
sure
you'd
that
have
we would have picked that up.
You
So
and Mr. Burton would have picked it up.
one of us you'd have hoped would have picked that up, including Mr. Burton's Leonard Jr. I suspect that I don't know how that's crept in.
And
I suspect that must have been the
you
final.
can't help me with what it means.
I think it's I assume it's an abbreviation for approved judgment.
Yes.
But I don't think it actually changes the language.
I think you just omitted
So we
it.
just
Exactly.
excise
That's how I've read it.
The
Yeah.
boundary between what is or is not flush.
And then just leave that out.
Yeah.
All right. Well, I just wanted to check whether you had any insights into what that might mean. And then the last sentence of that paragraph. No, I think I understand that actually. All right, that's really helpful. Thank you very much.
I'm very good.
Thank you, Mr. Rimmer. Mr. Burton, do you wish to reply?
Briefly, if I may, my lords and my lady, I was obviously somewhat short on my feet this morning. I don't intend to try and make that up now, just to make the point, though, that we still rely on the submissions made in our skeleton.
Of course.
Of course, my lad can address some of those. If I could just make some submissions under 3 brief headings, which are characterisation of the decision and significance of the 1998 guidance. Second, what could they have done? And then third, just to mop up some of these points about what this guidance actually means and its significance. So under the first heading, it's the appellant's submission, which I made this morning, but just to reiterate for clarity, that this is new guidance which is expressed to supersede and update previous guidance, but it is therefore current guidance in all material respects, even if some aspects of it remain unchanged from the previous guidance. And of course, this is a challenge to the guidance. As is clear from the detailed statement of facts and grounds, the skeleton argument below and the skeleton argument before you, it's squarely a challenge to the guidance itself. It being current guidance, as a question of principle, it has to be judged as a question of law on its own merits. And we say as a question of principle that must be right, and we also rely on refugee action. Also a do-nothing review decision type of case, which you get from paragraph 26 of refugee action. And then the principle, paragraph 152, which is effectively that the previous decision of the Secretary of State doesn't enjoy any extra benefit by virtue of not having previously been challenged. That the current decision, even if it's the same as the previous one, has to be looked at on its merits. And insofar, in the context of a Tameside challenge, that the Secretary of State wants to rely on the previous decision, the processes and evidence in relation to it would have to be brought forward in order to do so. So that's the proper context, we say, in which to analyse the guidance under challenge here. We say on that basis the Tameside challenge is effectively unassailable. Not only is it implicitly acknowledged by the decision to obtain further research, it's objectively correct for the reasons that we set out in the skeleton argument and the case. This is a piece of technical data that is seemingly based on no proper evidential basis. It must be right that the Tameside duty cannot be deferred, and insofar as my learned friend relies on the fact that further research is being undertaken, it goes nowhere in terms of the legal analysis. The Tameside duty would be no duty at all if you could defer it. That's also a totally novel proposition. It's either true or it's not that 25 millimetres fails for want of inquiry, or it doesn't, as a question of objective analysis. The question of rationality is slightly different, and I accept that, but there is some crossover. We say it's irrational both because there is no basis for 25 millimetres in the material before you, or the evidence before the decision maker, and moreover because of the presence of the UCL study. Imperfect as it may be, it was clearly the best evidence available to the Secretary of State, and I will take you to some aspects of the exhibit to the second statement of Ms. Franks in a moment. But it really just reiterates what we know, which is it's the only evidence. So what does my learned friend then say in order to demonstrate it's a rational decision to continue to advise that 25 millimetres is an appropriate minimum curb height in order to protect visually impaired people? Well, in relation to the relevance of the 1998 guidance, he accepts that he can't point to any empirical or expert evidence. Well, what does he therefore point to? We had two references to the 1998 document, which are at Supplementary Bundle 59 and 62. And I would invite the court just to take another look at these, see what they actually say.
Sorry, which pages?
59 and I believe 62. So we're coming from the 1998 guidance itself. And what we're looking for is some indication as to the evidential basis for the minimum curb height. Well, first of all, it says in the second paragraph that the guidance was produced as a product of consultation. Well, that may be so, but that doesn't of itself tell us that there was any evidential basis for 25 millimetres. And then at 62, my learned friend relies on the penultimate paragraph there, which is where we see the origin of the policy to use blister paving at all. And there it said that alternatives were explored of using lower curb heights instead of blister paving, but that it wasn't possible to find a compromise between wheelchair users and visually impaired people, which of course we know it's been the long-standing policy position that that compromise can't be resolved by a curb height, but can in fact only be resolved by having periodic level access crossings. But of itself, it doesn't support the contention that there was any evidential basis for 25 millimetres. So in our submission, going back to the 1998 guidance doesn't help us in terms of demonstrating any evidential basis for 25 millimetres. True it is that the RNIB said that they were happy with the guidance at the time, and that came from Ms. Fothergill's statement. But she then, of course, goes on to explain that at that time it wasn't deemed to be significant because there wasn't a problem with people constructing pavements that were lower than the standard height of 120 millimetres in 1998, but it has since become a problem. Paragraph 16, page 176 in the bundle. So then we must ask the question, well, how does the Secretary of State reach the conclusion that 25 millimetres is appropriate in light of the evidence that's arisen since the 1998 guidance? Because irrespective of the merits of 1998, we need to look at the current position.
But just pause a moment. But what Ms. Fothergill says is that what has changed is shared space.
Yes, I am going to come on to the significance of this guidance in that regard, absolutely, and I'm not going to duck that question. But it does have to do with what this guidance does and does not do, and indeed the current state of the moratorium in relation to shared spaces. But if I could just deal at the moment with whether or not there's a rational basis for 25 millimetres at all. The submissions made by my learned friend effectively rely on the TRL Stage 2 and Stage 3 reports and the inclusive design report. Now, the TRL ones, just to deal with them very quickly, I know that you have them already, but we need to be absolutely clear what my learned friend is seeking to rely on here, is first of all, 528 in supplementary bundle, which is the asterisked point. So it's 529. I apologise. So TRL commissioned to look at the available evidence, accepts that there isn't any basis, sorry, there is a basis for reconsidering 25 millimetres. It's not any endorsement of 25 millimetres, nor does it, needless to say, identify any objective basis for 25 millimetres. We then have the inclusive design recommendation at 111, which similarly references the Pamela research, which of course we know addresses the discrete question of detectability for visually impaired people, and makes the broader recommendation that further research ought to be carried out. Again, providing no objective basis for 25 millimetres being the appropriate detectable minimum curb height. And then finally we see the point made in the consultation response done by TRL, which is the document at page 548, but the references are actually in the table that we looked at page 575, where it said that this is a matter that should be considered later on, and that no change needs to be made just now. But again, there is no support from those documents for 25 millimetres being safe. So on the rationality question, we say the same point. We say effectively, the best evidence that's available is UCL. It's gainsaid by nothing. It may be imperfect, but the only rational conclusion is to provide a recommendation which is at least in accordance with the UCL evidence. And in that regard, anything below 30 millimetres struggles from a problem. There is nothing to suggest that the earlier UCL report had any deficiencies, and it's reiterated and reconfirmed by the second UCL research. The question about whether it should then be 40, 50 or 60 is clearly an open one, as discussed by the various reports. But there is no suggestion anywhere that it can be lower than 30, none whatsoever. And in addition to the UCL research, you then got all the visually impaired charities making representations to the Secretary of State that 25 is too low. The very people that this piece of guidance is intended to protect. And in light of all of that, one looks for some form of objective evidence that 25 millimetres is anything other than arbitrary. Some rational assessment of risk which would make it understandable to the very people who objected to it. And we say, despite my learned friend submissions, nothing has been put forward in that regard. So moving on to the second topic, what could they have done? Well, what they had to do is obviously act rationally, we know that. But if they're going to decide, as the Secretary of State did, to make a firm recommendation, despite the evidence of the inclusive design report, which said a firm recommendation is not possible, is reach one which is rational having regard to the evidence. We say there's no reason why you could select 25 millimetres in those circumstances. We don't go any further than that. But what the Secretary of State also did, and we saw that from Supplementary Bundle 134, which was the meeting with RNIB, is say, well, we don't want to change it now and have to change it later. That cannot possibly be a reason for promulgating what is otherwise irrational guidance, i.e. not based on any evidence. If you're going to make the decision to make a firm recommendation, it has to reflect the best evidence that there is, and there is, as I say, nothing to put up against the UCL evidence, at least as it pertains to 30 millimetres. And insofar as it matters, what would have been so bad about simply saying, we're changing this now in accordance with the UCL, it's the best evidence, we may have to make a minor modification in the future. An open reflection of the evidential position. And of course that leads on to what could otherwise have done. The Secretary of State could have decided not to make a firm recommendation, but to do something more caveated or more qualified, making it explicit in the guidance that 25 millimetres was not necessarily a reliable stipulation. So we say, in relation to Tameside, you can't defer it. We say, in relation to 25 millimetres, it's unlawful on its face, and that doesn't matter if it's only going to be there for a year or two, possibly, or 5, as the website actually says. It's unlawful from day one. And whilst the approach of Secretary of State has a seductive reasonableness to it, I accept that. Well, let's just not change anything until we've got the better evidence. That's not, in fact, what the Secretary of State did. And we have to grapple with that. It's unavoidable, even if it has certain pragmatic and awkward consequences. Because at the moment, there is nothing to tell people in the public or private realm who are applying their equality duties, as they ought to, that their 25 millimetres stipulation has no evidential basis to it. That is, as I said at the outset, the gravamen of this case. Which leads me to the third topic. What does this guidance actually do? And my Lord Justice Singh repeated an observation I made when on my feet this morning, the significance of which may not, if I may say, have hit home at the time, but I think it's reasonably clear now, that in relation to the first reference in page 179, under purpose of blistering, it's superfluous to the extent that what this piece of the guidance is concerned with is pedestrian crossings where there has to be a lip that is no greater than 6 millimetres. You could have this guidance achieve its purpose without any reference to minimum detectable curb heights. That does away with any practical difficulties that the Secretary of State purports to have been confronted by in January 2022. Just don't say anything about it in that part of the guidance.
If that's right, Mr. Burton, why is it of importance to your side?
I'm absolutely coming to that.
Right.
Please don't for a moment think, but let's first be clear what we are dealing with. I'd say that, first of all, the first reference to it could be done away with. The second one, as we now know, and I have to confess that I've been looking at the question of vehicular crossings in exactly the same way as I think everybody was until about half an hour ago, also now seems to have very dubious utility. Because if it's right that the vehicular crossings is supposed to work in the same way as it did in 1998, then it seems in my submission at least, difficult to understand why the 25 millimetres that divides the carriageway from where the car is driving up needs to concern itself too much with blind people who aren't likely to be coming up the same passageway as the cars.
You'd need to turn at right angles to
Absolutely.
encounter the curb.
Absolutely. So again, it's difficult to understand why it's there.
I thought the concern, and I may be wrong,
No, I'm not.
is that somebody may fall off it unless they can tell where it is.
If you take this drawing, that's the thing. We're all assuming, I think, here that we're largely dealing, because this is not a pedestrian crossing, we're dealing with pedestrians walking along the footway, as it were, horizontally, when we look at this picture.
But could they be crossing?
Well, this is not a pedestrian crossing.
No, I understand that.
But yes, if they just happen to be crossing there freely,
Yeah.
then yes, that you need to ensure that they know they're hitting the curb so that they...
I may be wrong, but that's what I had in mind.
Well,
that's why I've been asking someone to help me with what I should have in my mind.
Yes, well, I'm grateful for that, and I'm obviously very grateful for my Lord's questioning of my learned friend, because we've obviously, both my Lordship's questions on my learned friend, because we now have a better understanding. The appellant's position now is this, then, that there does seem to be still some utility, albeit limited, for the stipulation in relation to 25 millimetres. Now, as a question of principle, that still means there's a viable subject matter of this challenge. We don't need to prove some empirical level of impact. We don't need to demonstrate that a certain number of people might be at risk as opposed to another number, not least because, of course, as we know, no such analysis is incorporated into the Secretary of State's decision making. There is no risk assessment here of that nature. So one person is too many, to put it straightforwardly. But we don't know how many that number is. But we maintain our challenge. But it does, we say, reinforce the point that some qualification of the 25 millimetres would have been perfectly viable without undermining this guidance and without causing significant problems. But the flip side does not work. Simply because it's not necessarily of overwhelming significance doesn't mean it's permissible to promulgate unlawful guidance. Can't possibly mean that. There's no possible principled basis to make such a finding. But on the broader question, there are some incontrovertible facts, and I'm just going to list them so you have. First of all, there is no other guidance. My learned friend says, well, this doesn't purport to be guidance that deals with every kerb across the public realm, but it is the only guidance which tells people who are concerned about what level of kerb one needs in order to protect visually impaired people that emanates from the government. So we have to acknowledge that and take that on board. On the question of shared spaces, yes, it's correct that the current guidance on that has
Sorry, just
Yeah.
pause a moment. I understand the sentence you made, but if somebody uses guidance which is promulgated for purpose A in order to carry out purpose B, that wouldn't be a valid challenge, would it?
As a question of principle, I would understand that, but let's actually look what this is doing. It's in the first part, it explains the purpose for using blistering at all.
Yes.
And it says if you've got any curves which are lower than 25 millimetres, you need something else to warn visually impaired people. Ipso facto, if it's above 25 millimetres, you don't. Now, you don't need to be in a shared space environment to know that that's going to be potentially material to some design issues. It's identified in the literature as being a very important design principle. So I can't go so far, and my submission obviously is I don't need to. I can't go so far as to say that you need to incorporate in your analysis improper use of this guidance. That's not my submission. But one has to accept in real terms what the guidance says.
We've seen reference elsewhere to the figure of 125 millimetres.
Yeah.
So isn't that some guidance about what
No.
you're supposed to do? No? What's the relevance of that?
Well, historically, that was the specification that was used by some local authorities, as is explained by RNIB paragraph 16. But that is no longer the specification. There is just an absence of guidance. And this is where we come to the material point, which is paragraph 13 of the skeleton, appellant skeleton, includes the references for where low kerbs, either described as low or being 30 millimetres, are persistently causing problems. They're not shared spaces as defined by the Secretary of State's intervention, which says only level access. They are sometimes referred to as shared space, however. It's a nebulous term. It doesn't exist in any specific official document. But a feature of such spaces is non-existent or low kerbs. And so there is plenty of evidence that they are being created. So we say this in summation on what the guidance does. It has some direct, explicit reference which is intended to protect visually impaired people with the 25 millimetres. We don't know its extent, but we don't need to know it in order to establish unlawfulness, we say. However, insofar as there is any doubt about the broader significance of the guidance, that evidence about low kerbs, obviously informed because it comes from the three visually impaired charities who made representations to the Secretary of State, and has to be grappled with. Moreover, if it's necessary to do so, if the court is with the appellants that there is unlawfulness in promulgating the 25 millimetre guidance, then in our submission, the court can have regard to the broader factual evidence when it comes to the question of appropriate relief. The submissions on relief we have made in our skeleton, they repeat the ones we've effectively made below. There is some support for the contention that in relation to non-statutory guidance, the declarations can be sufficient, which explains why we put our case in that way. But now with the ingenious introduction of suspended quashing orders, we would suggest that this might be a case, should we get to that stage of the analysis, where one is appropriate, if only because delay is endemic in this question. It's 2018 when the point was first being made that we needed further evidence on safe curb heights for visually impaired people. It's 5 years later, we still don't have it. The evidence that we've been told is likely to come this year has a new stage, a stage 4, which hasn't even started yet, according to Ms. Franks in her second statement. It's said that we might get it by March 2024. Who knows? But in the meantime, just to make the obvious point again, there is nothing in the guidance to forewarn or restrict the development of forms of pavements or other interactions between road users and the carriageway, which would inhibit the use of curb heights, which we say the evidence suggests are likely to be non-detectable by a significant number of visually impaired people. And therefore some form of long stop remedy would be appropriate in those circumstances. Keeping in mind, of course, the Secretary has a variety of options to make modifications to the guidance today. Online, some modification could be made. There could be something on the website to make it abundantly clear that this part of the finding, this part of the guidance shouldn't necessarily be followed, or it's been subject to further qualification or review. A number of different alternatives are available. Even something, if I may say so, if it assisted, but I don't rest my case on this, saying this should not be taken to mean that you can have pavements which are, across, as my learning friend put it, across the public realm. You can't build pavements which are at 25 and assume that they're safe for visually impaired people. So there are a number of different options, effectively, that would be available in swift order, where the Secretary of State required to address what we say is an unlawful piece of guidance on its face. My Lords, my Lady, unless there's anything else I can assist with in terms of the submissions raised by my learned friend. May I just turn my back for 1 moment? I'm most grateful.
Well, thank you both very much for your very cogent arguments. We will take time to consider our decision. Could I, in the meantime, ask Mr. Williams to supply 2 more copies of the exhibit to Ms. Frank's latest witness statement? We now have 3 copies of the statement, but only 1 copy of the exhibit. You will, in due course, get a draft. That will come under an embargo, which means what it says, so it can only be shared with those on the distribution list that's already been given to the court. It will be your opportunity to correct our English, but not our reasoning, nor to introduce any new arguments. We would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions before the judgment is handed down, and we will make the order that we consider to be appropriate. The judgment will be handed down remotely, electronically, and there will be no need for any further attendance. Thank you all very much.
Court rise if able.